For judgment pertaining to economical gain, WPT 25 of 2025 and WPT 12 of 2024.
The writ petitions accordingly stand allowed and disposed of. No order as to cost.
For judgment pertaining to the principal seat, WPC 6452 of 2022 and WPC 5058 of 2022.
Writ petitions are allowed. Interim order, if any, stands merged. No order is to cost. Departmental records return back.
Deeply obliged, Lordship.
WPC 2129 of 2023.
Writ petitions stand allowed, disposed of. Mentioning, yes.
This matter was listed for motion on 10/9/2025. It was directed to be listed after 4 weeks, but thereafter it's not been listed till now, Malad. We have made applications also twice. Let it come to the vacation, Malad. On 8th, Malad.
What is the matter about?
It's a prolonged suspension, Malad.
Suspension, 8th.
Or
Let it
any
be
other
the
date
week after
convenient.
that, 22nd?
Mild.
22nd. Yes.
I'm praying for listing of an unlisted matter, Lordship, today.
Why?
Also, actually, an advertisement was published whereby
Published when?
it was published on 11. The client came to me yesterday and he was not aware that there will be a long vacation of the court. Therefore, I have to file it urgently. And actually, the
What
last
is the matter about?
Lordship, advertisement was published for a post of assistant professor in the Ayurvedic college. The age was given as 38 years, but there is a OM whereby it was extended up to 45 years. The advertisement does not follow that OM. Therefore, Lordship, the petitioner who is 41 years of age is unable to
All
reply.
right, you serve copies on the advance copies on the council for the others.
I
Response.
shall do it, Lordship. I'm going to file it. Can you taken up at 2, Lordship? As the last motion matter, Lordship.
All right, at 2 p.m.
Obliged, Lordship.
Daily list for motion, I think one.
Please, Lord.
Yes.
Malad, the petitioner is a sub-inspector of police. While he was in service, 3 DP was initiated against him. And in one of the DP, he was awarded the punishment of dismissal. Thereafter, he has submitted a representation to release his area's salary and other benefit. But the same has been denied on the ground that 2 more departmental proceedings is pending.
Yes, Mr. Sikya.
But instruction is necessary. Notice the issue,
Let council for parties issue notice which are removed 4 weeks. Mr. E.C. Sutia appears on behalf of all the respondents. Therefore, notices are waived. Extra copies be furnished within a period of 1 week from today. List this matter again on 2nd of February.
All right.
I think 2.
Matter pertains to family claim of family pension. Here, The petitioner is the second wife of the deceased government servant, my lord, and out of the wedlock, my lord, a child was born. And my lord, after death of the my lord husband, my lord, petitioner claimed family mentioned before the department, but the department has not considered the representation as of now, my lord. So, my lord, my limited prayer is, my lord, to direct the respondent authorities, my lord, to consider my representation or to dispose of my representation. My lord. That may be allowed.
She is the second wife, Lordship.
She is the
Second marriage, Lordship.
Second.
And
The second marriage will be governed by this full bench judgment.
Lordship.
What is the name of that?
Probably that applies to Mohammedan families, my lord.
Here is a Hindu law, my lord. The parties are governed by Hindu law, but the thing is, my lord, they have a child, my lord.
This minor would be entitled.
The minor child, my lord, at least.
So the representation, disposal of the representation, we'll have to say something.
Then, my lord, notice may go. My lord, at the same time, my lord, there is a possibility that the entire retirement benefit, my lord,
How old is your son?
It's a biological son, my lord.
How old?
9 years, my lord.
9 years.
9 years.
Two sons.
One.
First wife.
The
First wife have two.
The first wife had
Have
two, my
two.
lord. The second wife, my lord, the present petitioners, one. my
Well,
lord.
I heard counsel for parties, the petitioner claims to be the second wife of late Tilok Bodoloi, who
Not
was
my lord, 9, my lord, it will be 7 years, my lord.
Tilok Bodoloi, who was serving as a sub-inspector of police and posted in Golaghat district of Assam. Petitioner's late husband superannuated on 3007-2025 and died on 19/9/2025. It is the case of the petitioner that she is the second wife of late Tilok Bodoloi, and the marriage was solemnized on 22/10/2016 according to Hindu rites and customs. Out of the wedlock, a child was born, who is about 7 years now. So the counsel for the petitioner submits that the marriage of the petitioner with her late husband, late Tilok Bodoloi, is certified by the headman of Laupani village as well as the secretary of the Komargaon Gaon Panchayat by issuing two separate certificates dated 13/8/2025 and 14/8/2025.
There is a joint bank account listed, my lord, page 16, my lord.
The petitioner and her late husband also shared a joint account in the SBI at Nogam branch. And a copy of the account passbook is enclosed to the writ petition. Stop.
The departmental proceeding was also drawn, my lord. Focus notice was issued to the
Pursuant to the demise of the late husband of the petitioner, the petitioner has been claiming pensionary benefits, but the same has not been released. So it is the apprehension expressed that the entire amount will be released only in favor of the first wife and her children, to the exclusion of the writ petitioner or her child, who is also born out of a valid marriage between the petitioner and her late husband, late so-and-so. So petitioner has represented before the authorities on 14/10/2025 by representation, which according to the petitioner has not been disposed of. Being agreed, the present writ petition is filed before the court. Whereas the Mr. J.K. Goswami, learned additional senior government advocate,
1, 2, and 5, Lordship.
appears on behalf of respondents 1, 2, and 5. Mr. B. Sharma for respondent 4, MSH Purva for respondent 3. The first wife is also carried as party respondent number 6. So the law in this regard is clear. The apex court in Rameshwari Devi reported in so and so has in no uncertain terms held that while pension may not be available to the second wife, however, the children born out of a marriage with this between the pensioner and his second wife will be are legitimate children and are therefore entitled to their share of family pension as permissible under the rules. So, under the pension rules governing the pension and benefits of employees of Assam, Rule 143 clearly provides that pensionary benefits up to for the sons will be available till they attain majority at the age of 18. So, the son of the petitioner is stated to be 7 years old. Therefore, in terms of the law laid down by the apex court, the son, who is a minor now, will be eligible to stake a claim for his share of pension, a family pension, which is payable to the dependents of late Tilok Potoloy. So, in that view of the matter, this court is of the considered opinion that the matter is required to be decided by the department, and therefore, without issuing any notice at this stage, this court proposes to dispose of the writ petition accordingly. Stop. It is therefore directed that the respondent number 5 will examine the claims of the petitioner as ventilated in the representation dated 14/10/2025, stated to have been filed by her. And upon due examination of the claims and verification of the necessary documents, if it is found that she has a child who out of the wedlock of the writ petitioner and late Tilok Potoloy, then in terms of the law laid down by the apex court, his claim for the appropriate share of pension should be worked out and be released in terms of the rules prescribed under the Assam Services Pension Rules. Stop. Under such circumstances, the claim of the petitioner should be decided by the respondents by due examination, verification of the reports. This entire exercise be completed within a period of 90 days from the date of receipt of a certified copy by the respondent. Writ petition disposed of.
Lordship.
Full bench decision was rendered in the case of Junufa Bibi.
Junufa Bibi versus Padma Begum.
Padma Law.
Ah.
That is related to Madam-
2022. It is Mohammedan law. Lordship.
উপরে লিখি দিব Rameshwari Devi legal. That followed a reference in this regard is also required to be made to a judgment of a full bench of this court rendered in Junufa Begum,
Oh, yes, Junufa Bibi.
Bibi.
Junufa Bibi.
reported in
2022, Lordship.
reported in 2022, so and so forth.
Lordship, this matter is related to the Mohammedan personal law, Lordship. Now, our case in hand is Hindu personal law, Lordship. But Lordship,
But Rameshwari Devi will govern-
yes, Lordship.
And there is a subsequent judgment of the High Court also,
Well, there is a Supreme Court judgment also. that-
Suraya Begum.
That's right.
But that again is also Mohammedan law.
Lordship,
So I think Rameshwari Devi is good enough.
it is better. Lordship.
Otherwise, law is clear. Law is clear.
High level assembly.
Yes.
I think
মাটি বলে উঠি তো আপনি একটা কাম করো সব মাটি লোক যাতে বস্তুটো কথা পাতি তোৰ লগত কি কথা পাতিছিলি গতিকে চাবলৈ দিওঁ মই উঠাই পিছত গৈ পেলাই চাম। Yes.
May I please, Your Worship? Here, my lord, petitioners are working continuously for more than 14 years, my lord, as grade 4 Sahayak under Dhemaji Electrical Subdivision, my lord. Although the last occasion, my lord, the Honorable Court had directed to.
Where is the impugned order?
My lord, at
Page 60, my lord.
page 58, my lord, Annexure Z, my lord. They have wrongly misinterpreted and misexamined, my lord, the petitioner's service, condition of service, my lord, and negated the claim of the petitioner, my lord.
So what is to be done now? How, why is this illegal? They said that there is no, after verification, you could not produce continuous payment of records.
My lord, they have continuously working, my lord.
May
They-
have
they
been working,
taken
but
some-
you cannot provide. How will this court find out now? Unless you produce the documents.
My lord, Annexure, my lord, C, D and E, my lord, they have itself admitted that they have continuously working, my lord, under this department as Sahayak. my lord. Kindly see, my lord, C1, page 34, my lord. 35, this is certified that C1, C2 and C3, my lord, they have admitted, my lord, they have working, my lord, under this department as Sahayak, my lord. Last more than 14 years.
No, my lord, it is from 2008 to
My lord-
2011 only.
They have, my lord, Annexure E, my lord, E series. The department
It
has,
is not possible now for this court, once we have already directed, they have found out, you give us some input, information to show that no, this finding is incorrect. Otherwise, how do we,
my lord, they have working, my lord.
the mere statement will not do. You go and file a
This
title
is, my
suit.
lord, their documents, not.
You go and file a title suit, get it proved. You are coming to the writ court. Mere statement that they are working vis-a-vis the finding of the department upon verification that you are not working.
Even, my lord, D, Annexure D series, my lord, ID card, my lord. Department's ID card.
What is the finding of the department here?
My lord. 59, my lord. Last two paragraph, my lord. Now therefore a committee dated so and so. The purpose of verification of payment
And
record.
according to you, the committee could not produce continuous payment records.
Only continuous payment record, they have, my lord, I stated that they have not produced continuous payment record, my lord.
But the continuous payment record is for, my lord, because they have to show that they are working continuously and as such they are getting payment from the department, my lord. So they could not produce it, my lord.
What about these ID cards?
My lord, the ID cards, my lord, as a Sahayak, my lord.
These ID cards are issued by APDCL.
Yes.
For what purpose?
My lord, that I have to finish. The page number.
Why did you issue ID cards if they're not working? Heard learned counsel for parties issue notice returnable 4 weeks, Mr. B. Das. Learned standing counsel represents all the respondents. Therefore, notices away, the extra copies be furnished within a period of 1 week from today. The challenge in the writ petition is to the order dated 4/8/2025, whereby the claim of the petitioners that they were working as Sohayaks under APDCL has been negated. Stop. The speaking order reflects that a committee was constituted on 1/7/2025 for the purpose of verification of payment records and other relevant documents of the petitioner, and upon verification, the petitioners could not produce continuous payment records reflecting remuneration for substantial working days in a month. And accordingly, their claims were rejected. Stop. Counsel for the petitioner on the other end submits that they have been continuously serving and there are sufficient records, including issuance of proper ID cards. Stop. Therefore, the conclusion arrived at in the speaking order is contrary to the records. But having heard counsel for parties, let notice issue returnable after 4 weeks. The standing council will complete their instructions and file necessary affidavit. The records connected to the writ petitioner, including the reports of the committee, be placed before the court on the next returnable date, placed on 2nd of February. Borua, you're appearing for finance. H. Borua for the finance department. Placed accordingly.
Please.
Or
বলেন হ্যাঁ তাহলে কি লিখলি এটা তো ভুল হবে বুঝলে একটু দরকার হলে আপু এবার অ্যানাউন্স করতে লাগবে
May I please, Your Worship? This matter relates to the appointment on compassionate ground. DLC recommended, the SLC rejected.
Just 1 minute. মই অলপমান চাব লাগিব তাৰপিছতে খবৰ দিম মই কিন্তু যিমানটো মোৰ মনত পৰে কৰিবলৈ আছে চাব লাগিব সাবসিকুৱেণ্ট তাৰ কিবা থাকিব পাৰে তাতে ডিক্টেশ্যনটো চাবলৈ Yes.
Well, this matter relates to appointment on compassionate ground. DLC recommended, but SLC rejected. Then I approached this honorable court, directed the respondents to place my matter before the SLC again for reconsiderations. My lord, that my matter was placed before the SLC and SLC's minute cease met Annexure 8 page 41.
When are you claiming? When was your claim? For which year?
2011, my lord, DLC of 2012.
2011 claim for
My lord,
compassionate appointment. You are in court. We are looking into
Content.
whether your claims are permissible.
That is.
How have you survived?
That is another aspect.
No, that is the main aspect. This is compassionate appointment.
Correct, my lord.
Then
But this,
you have to explain how you have survived for all these years
I
without a job.
I approached this honorable court consider my case and it was.
I don't think it is possible to continue
Your lordship, kindly consider.
compassionate appointments like this.
That is, my lord, page 42. In respect of my case, my lord, what is the decision of the, my lord, SLC? 42 second paragraph, my lord. Further cases of the following candidates are examined in this meeting as per existing OM so and so, and they decide to defer until a final decision is taken in the matter. My serial number is 1.
No, that's all right. These SLCs and all, they have taken a decision on the basis of their judgment, which came to be interfered with recently by the writ appeal. That's 3 years.
3 years. 3 years.
Your case was rejected on the ground that you did not have 3 years.
3 years.
That
That-
was allowed in the writ petition.
Appeal was filed by the state.
That
also.
has been dismissed.
No,
Huh?
it was not interfered. That is,
Huh?
it was not interfered by this division bench.
That's what we said. It was dismissed.
Writ appeal was dismissed by the, filed by the state.
That is what we are saying. Writ appeal is dismissed,
My lord.
upholding the single judge's order.
Yes,
Now the question is,
Question is only, my lord, the 2011. Can, my lord, this continue?
that, in that respect, an observation has been made by the, my lord, division bench, my lord, also.
observation, where is that?
That is para 21, my lord, that is we thus affirm the regulating order passed by the learned Singh. That was.
Hmm?
That's 22 is paragraph 22.
Hmm.
It is observed by the passage of time also, my lord, one of the condition, but it is.
That's right. That is what we are saying.
My lord, in view of that, my lord, my writ petition may be disposed of, my lord, because all the matters that will be referred,
No, my lord, that is gone, my lord.
Now you consider it.
yes, in view of that,
You consider the long
Yes.
lapse.
they can.
Have you seen that order? Judgment, para 22.
There are 22, my lord. I have
You consider it. While considering this aspect, you will also consider the
There were-
long
there were-
lapse.
That,
With-
that time factor also may consider.
So that liberty is granted.
Yes.
Cause, my lord, in that series judgment event that is there, my lord.
Hmm?
For consideration, my lord,
Hmm.
we have to take in Devabrata Tiwari, my lord, that is also there.
Anything.
Have you seen the judgment, writ appeal judgment? Have you
Yeah,
seen
yes,
it?
my lord, para 20, I have seen.
So we are only going by para 22,
Well-
not by anything else.
My lord.
এই, তুমি কথা পাতি লৈছিলো। কালিতো তুমি মোক বেলেগ ক'লা। কালি মই সুধোতে you said something else. Third counsel for parties. This writ petition is filed by the petitioner, putting a challenge to the order
Itu, my lord.
dated but challenge the minutes of the SLC dated 2/3/2023, whereby the name of the petitioner, which had appeared amongst the candidates whose claims were rejected. So the claim of the petitioner was rejected on the ground that his father, your father did not have minimum of 3 years service left to the credit to his credit, after his expiry in harness, in terms of the OM number so and so dated 1/6/2015. Page number 42. Pencil D tick mark করেন, huh? You approach the High Court,
My lord.
the petitioner along with other similarly situated petitioner that approached the High Court being WPC number 7117 of 2019, whereby coordinate bench by order dated 12/12/2022 allowed the writ petition, disposed of the writ petition, interfering with the but this is some other minutes.
Minus SLC rejected earlier, then we challenge.
No, this order 2/3/23. Is
Yes.
it under challenge? No.
2/3/23, it is under, this in this writ petition, it is challenged. In this writ petition. Because SLC is rejected, then we approach and this honorable pass an order
No,
for
no, no.
reconsideration.
This rejection is in the year 23.
23.
Why have you come after 2 years?
My lord, it is written, my lord, the page 42,
Huh.
the decision was deferred. Decision was not taken, my lord.
May not be, but
My-
the decision was rendered on 2/3/23.
My lord,
You have come after 2 years.
that is correct.
Why?
It was deferred because no decision was taken, my lord. We are, in the meantime, my lord, this.
No decision was taken. It was
My-
deferred, but the decision was rendered on
Yes,
2/3/23.
that is correct.
Then after 2 years, why have you come?
Well, in the meantime, my lord, the similar writ petition was.
We don't know you had accepted this order for 2 years.
Yes,
You had accepted this order, rejected.
rejected.
Now suddenly, why have you raised your risen from the dead?
My lord. Because writ appeal was pending and
You
on the
did
same.
not come to the court.
It is,
Then
that issue was pending before
when
the,
it was pending
My-
on somebody else's case, you were not concerned.
but on same issue, my, that is. the-
You did not come to the court.
Yeah, earlier after
Now
2020,
it is for the
immediate.
government to decide if they want to consider all your cases, they will do it. Why should we entertain your writ petition after 2 years?
My lord, my lord, these decisions may be taken, my lord, is per their, my lord, minutes.
Why should we direct them? That means we have to interfere with the decision after 2 years. What is the ground?
That, my lord,
Today, if some order is passed and a writ appeal or an apex court delivers a judgment after 5 years, is it a ground to go and file a fresh writ petition?
because I was not the party of that.
You are not a party
My-
because you did not approach the court. You accepted this order. You accepted the rejection order.
Actually, not rejected, my lord, their decision was deferred. That is the problem.
Decision was deferred and finally rendered in 23.
That is, only it is deferred possibly because of that writ petition pending, writ appeal pending.
What are you saying, Mr. Counsel? See come to page number 41.
What?
Kindly read the heading of that. Kindly read. This is the minutes.
Yes,
Held on 2/3/23.
my lord.
Where do you find the word defer?
My lord, in decision of the meeting, my lord, it is written.
Ah,
As the minimum service period of so and so, the matter is deferred until a final decision is taken on the matter.
No, these cannot be, my lord, because the stay order of that writ appeal, my lord, was 25/1/24. So maybe for some other reason, it was kept pending. This is of 2/3/23, the minutes, my lord.
Then-
Whereas the first stay order was issued on by this division bench, my lord, on 25/1/24.
Then we filed representation also.
Representation is on,
All right. Right. WPC 711/2019 dated 12/12/2022, whereby the earlier decision taken was interfered and the matter was remanded back to the state level committee to reconsider and to complete the exercise within a period of 45 days. Subsequently, the matter was again decided by the state level committee held on 2/3/2023. And insofar as the writ petitioner and 4 other candidates are concerned, where the concerned government servant who had died in service and who and the claims of their dependent members for compassionate appointment, where hit by, what is that clause number? 1.
Clause number 1 of
Clause number 1 of the
This
OM
number.
number so and so dated 1/6/2015, which stipulates
15.
that minimum period of 3 years service, if not left for the deceased who died in harness, the cases will not be considered, therefore, in view of the litigations pending before the High Court, the matters to differ. Litigations tend to differ, matters to differ. Stop. Learned Counsel for the petitioner submits that this decision was deferred in the light of the pending litigation before the High Court, whereby a coordinate bench of this court in a bunch of writ petitions where the lead case is WPC so-and-so Bhaskar Kumar had allowed those writ petitions by interfering with the clause 1 of, by setting aside clause 1 of the so-and-so OM. So these matters were appealed against by the state before a division bench of this court, where the lead case is writ appeal number 287 of 2023. Stop. The division bench finally sustained the order of the coordinate bench, affirming the conclusions reached. However, while disposing of the appeals, the following directions were made. Para 22. The para 20 Para 15 over the 15 to 23. Stop. Para the present writ petition is now being filed, placing reliance on the judgment passed by the appellate court. To seek a direction to the respondents to consider the cases in the light of the directions issued by the writ appeal, in the writ appeal. Mr. R. Dhor, the State Council, also does not dispute that the writ appeal has recently been rendered, upholding the judgment of the single judge passed in WPC so-and-so and other bunch of cases. He, however, submits that in terms of the office memorandum dated 18/9/2024, read with the judgment of the apex court rendered in Devabrata Tiwari, reported in so-and-so, the cases of the petitioner do not require any consideration. So, where having heard counsel for parties, it is seen that the SLC in its meeting held on 2/3/2023 had considered the cases of the writ petitioners, but had deferred a final decision on the matter. Stop. Therefore, at this stage, without issuing notice, the court is of the considered view that the matter can be closed, directing the respondent authorities, namely the Chief Secretary. Chief Secretary. Respondent number 2. To take a decision in respect of the writ petitioner. Which was deferred in the earlier, by the earlier minutes dated 2/3/2023. So the state level committee will consider the cases of the writ petitioner by taking into consideration the conclusions arrived at by the division bench in writ appeal so-and-so and other connected matters, the relevant paragraphs of which have been extracted below, above. In terms of the above, writ petition stands disposed of. Needless to say, any decision taken by the SLC, copies thereof shall be furnished to the writ petitioner. Disposal.
Okay.
Item 5.
The Child Development Project Officer Lanka ICT Total Lordship issued advertisement for the post of Anganwadi worker Lordship. Then petitioner and except for Lordship page 17. Including the center of the petitioner Lordship. The petitioner applied for the same post Lordship, but the response authority rejected the candidature of the petitioner Lordship. Annexure 6, page 29. Lordship. On the ground, there's the out of survey area. Even though Lordship, the petitioner is the belong to the said Anganwadi Center, Oxek Pathar Anganwadi Center Lordship. Annexure number 3 Lordship, this is the voter ID card from the same village.
So one of the conditions that candidates of the for a post of Anganwadi worker and helper must be the resident of survey area, Lordship. That's why he has rejected, Lordship.
Let me kindly see the annexure 3 Lordship, page number 16. And this is the voter ID card.
You get your instructions here. Heard counsel for parties. The Mr. A. Chakraborty, the state council will obtain instructions in the matter, for which extra copies be furnished today. Can you do it? The extra copies be furnished during the course of the day. Matter be listed again on 19th January.
God bless.
Similar.
No lordship, no lordship.
In this case, Lordship, the president of the Anganwadi Central Lordship filed this petition, Lordship.
President.
There's no locus standi, lordship, first of all. And
Or-
second, lordship, there is no, the premature case, lordship.
Lordship, kindly see, Lordship. You kindly see the select list, Lordship,
Yeah, how are you
Page-
concerned?
page number
Yes.
38, Lordship.
How are you affected?
I am affected, Lordship. I am the president, Lordship.
What is your duty? What do you do? Are you a member of the selection board?
No,
No, Lordship. I am the managing committee member, president, Lordship.
What is to be done? What is your duty?
As a duty, Lordship, the local candidate may be selected, Lordship.
That is,
that will decide
that
by
you
the
go and
selection
file,
committee,
that you
lordship.
go and file some public interest is a different issue, but
Yes.
in your capacity as the president,
Lordship.
you represent before the Director Social Welfare?
But I filed a representation before the deputy commissioner, Lordship.
How, what is deputy commissioner, who's the deputy commissioner here? Is he a member of the selection board?
No,
No, Lordship.
Then,
Filed a representation before the deputy commissioner to select the genuine candidate, Lordship.
who is the selection committee? Who selects? Where is the selection committee referred to? Describe, prescribe, where?
No, Lordship.
Huh? Who selects?
CDPO, lordship.
CDPO, lordship, and
There is a
then-
committee, lordship. We have a committee, lordship.
Where is that committee? Is the DC a party?
No, lordship.
No.
Then why should we keep on issuing directions to all and sundry? Unless you show that you are a part of the selection committee or
It is
DC is not a part of the selection committee.
This is the head of the administration, Lordship.
The head of the administration is all right, then you write to the chief secretary, ask him, he's the head of the administration of the state.
Even lordship, in this writ petition, lordship,
We are dismissing it.
yes, lordship.
Lordship, before this meeting, Lordship, kindly see the page number 50, Lordship, Annexure 6, Lordship.
Page
Page 50,
50.
50, Lordship,
Ah.
Annexure 6.
Ah.
The responsible authority that selected the candidates who is the another Anganwadi center, Lordship.
We are not entertaining a public interest litigation here. You are not a person applying for that post. You are the president of that Anganwadi center. You are unable to tell us what is your duty as a president. What do you do? What responsibilities are vested on you? You begin by saying that you are you are a social worker of the locality.
Lordship.
Then what social works do you do?
Lordship, the local candidates, belong to the Anganwadi state center, Lordship, they may be
You go and
selected, Lordship.
represent before the concerned
Lordship,
authorities.
yes,
Why
Lordship,
why you
yes,
coming to the
Lordship,
court straight away?
Number 5
You
select-
go and refer to
selected,
the
Lordship, who
the
is
respondent
another
authorities.
Anganwadi center, the Sitpur Parul
Third
colony,
dismissed.
Lordship. Lordship.
One more word will impose a heavy cost.
Lordship.
Item 7.
Right, Miss Lordship. Lordship, I was appointed as data processor, Lordship, in the office of Badapur Town Committee. Lordship.
Yes, respondent,
Lordship, issue
why
notice,
salary not
Lordship.
paid?
Lordship, issue notice,
Why
Lordship.
should we issue notice?
Lordship, respondent of 5 is the necessary party, Lordship, here, Lordship. Employee of the Badapur Town Committee, Lordship.
No, but there is an executive officer.
Lordship,
Who is the executive officer?
not made a party, Lordship.
Who is he?
ACS officer, Lordship.
Then
Not made a party, Lordship.
you are representing the directorate.
Director, Lordship.
Yes, get instructions from them.
So
Why should we
employee,
issue notice? It's only a question of non-payment of salary.
Lordship.
Get that information.
Employee of the municipal town committee, Lordship.
Under which department? Who's the parent department?
Our
Who
director,
represents the parent
municipal,
department?
director municipal.
Who represents? And who is representing the department before the court?
Executive officer, Lordship.
And who's representing the department before the court?
I'm-
Get your instructions, sir, counsel for parties. the government advocate is permitted to obtain instructions from the department. Regarding the claim of non-payment of area salary, matter be listed on 19th of January. Extra copies be furnished during the course of the day.
Obliged, Lordship.
My lord, this matter led to the nomination, my lord. The petitioner is the legally married wife, my lord, but her name was non-nominated, not mentioned in the nomination, my lord. Another lady was mentioned, my lord. That's why, my lord, petitioner filed a representation before the authority, my lord, but not considered. That's why, my lord, I filed this. May I tell the only notice be issued, my lord?
Heard counsel for parties issue notice. Returnable 4 weeks. Who is for water resources? Mr. R.M. Das. He appears for water resources. Please give him copies. Appearing for respondents 1, 2, and 3.
My,
Therefore, notices are waived. However, extra copies be furnished within a period of 1 week from today.
my,
Steps on respondent 4 and 5 by registered post within 1 week from today.
may I be, date may kindly fix, my lord.
28th of January, list
My
on.
lord, maybe delay, maybe middle of.
Later.
Later, my lord.
All right.
February.
11th of February, list on 11th February.
Must.
Nine.
Yes.
May please, Lord. This, my lord, regarding compassionate appointment, my lord. Second round of litigation, my lord. Earlier, the petitioner approved this all court. And this all court, my lord, page 30, my lord, there's a direction to place his case, my lord. Before the DLC.
Because.
Page 29 is the order. my lord.
Yes. Then
Then, my lord, his case was placed before the DLC. And DLC, my lord, page 33. Meeting was held on 29, 2024. And his name was selected and recommended, my lord, page 39.
oh, 39.
Lordship, his name, my lord, page 39, he was selected and recommended for. And by letter, my lord, page 40, letter dated 8/10/2024, it was recommended to the SLC, my lord.
Then
Then, my lord, the impugn order, page 41, by relying a official, my lord, her case was not considered, saying that no case will be considered further. Page 41, my lord.
that office memorandum is there.
Official memorandum was challenged before this all court, my lord. It was, my lord, hold that the case which are pending, my lord, that will be considered as per merit.
That is the consent order.
Lordship, by the, on the basis of, my lord, submission made by the honorable, my lord, AG, my lord. And thereafter, my lord, similar order was also passed. That was also, my lord, said at page 60, my lord, directed that the case should be placed before the SLC for consideration on merit. Because our case, my lord, prior to this notification. Page 57, my lord, paragraph 9, my lord. By this honorable court.
But there is no discussion on the office memorandum.
In
There is an office memorandum where it says that no further consideration.
lost.
Yes.
Somebody will have to challenge this.
That was challenged, my lord.
Where?
Before this on court.
Huh?
Before this on court, my lord.
By what order was passed?
And page 50, my lord, this batch of writ petition was filed, my
No,
lord.
no, that
The consent order
that was an order on the basis of the consent given by the council. There was no direction for interfering with the office memorandum. This
This case also-
order that you are referring to at page 60
Lost.
does not consider the office memorandum. It only refers. It does not say what is the effect of the office memorandum. The matter is closed and remanded back to the department without referring to the consequences of what will happen to the office memorandum. Can it be
Now-
ignored?
Now, my lord, paragraph 7, my lord.
Hmm.
Your lordship kindly issued, my lord, paragraph 7.
Of
Page 56, my lord, of the order of this on court.
56,
Or-
yes.
Further into the issue as to whether the
Paragraph 7, my lord.
Yes.
Consent.
Without going
What has
into,
fallen from my lord.
Hmm?
What has fallen from my lord, there was, my lord, this OM is not interfered with.
Authority can taken into consideration.
Only,
And this is also not covered because it is not filed before.
And also there was some rider that all the matters which are pending till the
Yes.
date of the order or something like that.
And then before 3/4/2025. It has been filed in that.
This is not it doesn't, it's not a binding precedent. Technically, because it doesn't decide anything.
thereafter also, my lord, another order, page 60, my lord.
60 order we are referring to.
I lost it, page 60.
60 has referred, you come to page number 61.
61.
End of para 2, you'll find there's a reference to the office memorandum. And para 6 is the disposal order. But there is no reference as to what has happened, what will be the effect of the office memorandum.
That was not decided.
Then,
So, my lord, my case is exactly same, my lord.
no, it's a council.
Lost it,
There is an office memorandum.
lost.
Rightly, wrongly, correct, incorrect, there's an office memorandum. Once that office memorandum is there, the authorities are not bound to consider. How as we courts are issuing direction to the department to consider ignoring their office memorandum, we'll have to interfere and set aside. Has it been done in the order?
No,
Then,
because there is a consent from that the case pending, that will be considered on merit.
I don't think there is a consent here.
That-
In the subsequent
that-
order.
That to before 3/4/2025 pending, not beyond that.
it was like a one-time measurement.
No. Page subsequent order, page number 60, 61.
No, there is no consent, my lord, because relying the earlier order, that was followed.
No, even earlier order is not relied on. You see page number, para number 6.
Having,
No, para 4 they have given a consent. Yes, Mr. Sutia and Mr. Dhor. Para 4 there is a consent of your colleagues.
My lord,
Mr. Deori.
here in page 41,
Uh,
we have specifically invoked the OM, my lord.
Come to page number 61, para 4.
Tell me that they have no objection to the grant of disposal of the petition directing the respondent to declare that case. That is the.
My lord. My lord, it may be, my lord, but the thing is here, my lord, in this case, specifically in page number 41, my lord, we have invoked, the department has already invoked that OM, my lord. Meaning thereby, my lord, we are not giving consent, my lord. That is specific, my lord.
No, but why, what is this? The government has to speak with one voice. Some matters you are giving consent, some matters you are not giving consent.
The Honorable AG has given consent before this on
My
court.
lord, in the batch of writ petitions, but that was like one-time measure, my lord. Only
In the subsequent matter also you have given consent. The orders of the court must be uniform.
And in page 58 also, my lord, paragraph 10, my lord, lordship kindly see. There's a discussion, but. Paragraph 10, my lord.
My lord.
In the middle, it is also directed that while.
My lord, another thing, OM is not under challenge. He has to overcome, he has to show how the OM is bad in law, my lord. Without, my lord, showing the OM.
That we are aware. We are only asking you that the government has taken a stand that we have no objection. Now, the obvious question would be, why do you have an objection here if both the cases are similarly situated?
My lord, now we have a specific order from the government, my lord, in page 41. This is the stand of the government. This is not in a courtroom, my lord. This is a specific administrative order, my lord. The government has issued from the directorate, my lord. Oh, no, this page 41 is from the government itself. So, my lord, now I cannot, as a council, my lord, I cannot just go beyond this, my lord. In that case, my lord, maybe there was no specific order, but here, my lord, I have a specific instructions, my lord, from the government, my lord. So I have to stick to this, my lord. And unless, my lord, that poem is set aside, on basing on which this order is passed, my lord, we have relied on an OM. The OM has fallen from Debabrata Tiwari, my lord. Unless that OM is interfered with, my lord, how there is no consent, my lord, because specific, it is very specific, my lord, here, in this case.
After the consent order, Malad government has issued a notice and Malad executive order. Those who are pending before this honorable court on 3/4/2025, they should submit their application, keeping the last date 15/9/2025. Because this case is not covered because it filed in December. It was not pending before Malad 3/4/2025. Only paragraph 4, Lala Devi, he has given the consent, my lord, for disposal. This does not mean, my lord, the office memorandum has.
You have not challenged the office memorandum.
Not challenged.
No, in this case, no.
How it is.
In view of the office memorandum, unless they give a consent, you cannot allow the writ petition.
And we'll amend our chairman.
Yeah, up to you. You withdraw and file afresh if you want. Heard counsel for parties in the counsel for the petitioner after submitting at some length seeks liberty to withdraw the writ petition. And file a fresh prayer made is allowed, writ petition dismissed on withdrawal with liberty.
Okay, no problem.
Mr. J.S. Sutia and T.C. Sutia and Mr. Hardford appears for the respondents. And government council, you should decide in similar matters, your submissions across the court should be similar. In some matter, you are giving consent, some matter you are not giving consent.
So, my lord, here my stand is, my lord, only because there is a, my lord,
We don't know that. We are only conveying the difficulties from this side.
I bow down, my lord. I am only on that, my lord. There is specific order, my lord. That's why, my lord.
Then
My lord, in this case, my lord, we have earlier challenged the OM, and pursuant to that challenge, this honorable court has directed page 49 onwards to consider our case before the SLC. And pursuant to that, my lord, the government has issued notice. We have participated pursuant to that notice. The matter is under process before the government, my lord. Now, I have challenged the SOP, page 73, whereby they have decided to prepare a list that those whose cases were considered on or after 3/4/2025 or whose cases were pending as on 3/4/2025. And the similar matter, your lordship was pleased to this honorable court was pleased to issue notice with an observation that pendency shall not be allowed.
With the observation that
Pendency shall not be about to consider case.
So, my lord, page 77.
give us that order. Heard counsel for party issue notice returning of weeks, Mr.
They have stated that they have not
I am
rejected.
for
our
1
claims.
and 2, my lord, and 4.
equally covered, my lord, that the similar association.
Mr. Sutia appears for
1, 2, and 4.
1, 2, and 4.
4, 5, 4, 5, 2 there.
Mr. Ardhor for respondent 5. Who's for respondent?
I am appearing for respondent number 3,
only.
secretary.
He does for respondent number 3. If the respondents are represented, notices are waived, extra copies will be furnished within a period of 1 week from today. Pendency of the writ petition shall not be a bar to consider the case of the writ petitioners.
Deeply opposed.
11.
May I please? This is for denying my joining in Assam Police Constable as a criminal case is pending, my lord, against me.
You are an accused,
Yes, my lord.
then
But my lord, what is?
subject to police verification.
Yes, after police verification, my lord, they neither communicate the letter of not allowing, my lord, not doing anything. Just say you are not allowed to join the. my lord.
No communication.
No communication.
Yes, Madam Borua, please obtain instructions here.
Yes.
Third
Whether
con-
communicate or
consensual
not.
Parties claim the petitionary is that after having been successfully selected and shortlisted for joining in which department?
Police, Assam Police Department.
Assam
Constable.
Police. For the post of constable.
Yes, my lord.
Constable. The petitioner has not been permitted to join as there is a criminal case pending against the petitioner. Stop. However, the petitioner has only been verbally informed and no communication has been issued to the petitioner. Who is the private respondent?
Private respondent is the informant, my lord. In this case, I am accused. Actually, what happened, my lord? For a
Right,
moment.
right. Let the respondents complete their instructions and obtain necessary complete their instructions and apprise the court on the next date fixed. When can you get it?
Huh?
22 January.
21st.
My
21st of January.
lord, one thing I want to submit, my lord. I have to report, my lord, on 10/12/25. Then the batch will be started, and after that, my lord,
What is today? What is the date today?
it is 19.
You have to report when?
10/12.
Today we are on 19th.
My lord.
Then did you report?
Then batch should be start from 3, my lord, 3 January.
then-
So immediately, my lord. opening the
Immediately,
book.
all right, 7th January.
9 January.
7 January.
Right. Deeply obliged.
Obligations.
Supplementary list for motion item 18.
May I please, Lordship? Lordship, at the outset, I humbly submit that Lordship, this is a covered case, Lordship. The judgment is annexed at page number 39. Before going into the judgment, Lordship, may I submit the gist of the matter, Lordship? Lordship, may I submit?
Yes.
Lordship, the petitioner applied for the post of Junior Engineer Civil under PNRE Department, Lordship, pursuant to an advertisement by advertisement number 3 of 2020, Lordship. Subsequently, Lordship, the petitioner was allowed to appear for the screening test. Lordship, the petitioner successfully qualified for the screening test. He was called for the document verification also, Lordship. As the petitioner belongs to EWS category, Lordship, he has submitted the EWS certificate along with all the documents, Lordship. Thereafter, what has happened, Lordship, the petitioner did not find his name in the final result, Lordship. So what he did, Lordship, he filed an RTI applications, Lordship, regarding what is the status of his candidature, Lordship, and how much marks he secured, Lordship. So through the RTI reply, he found that he secured 127 marks, Lordship, 127.5 marks, Lordship, and his candidature was rejected on the ground of his EWS certificate was invalid, Lordship. Similarly, he also approached before this honorable court, Lordship, and this honorable court has directed the authority to disclose the aggregate marks secured by the candidates, Lordship. Taking cue of this order, Lordship, some other similarly situated petitioners has come up before this honorable court, Lordship, that their candidature has also been rejected on the ground that their EWS certificate has is invalid, Lordship. And whereas they have secured more marks than those have selected in the under EWS category, Lordship, and even they crossed the cutoff marks of 113, Lordship. So that is the case, Lordship. The judgment is at page number 39, Lordship, by way of which this honorable court has directed the authority to provide appointment to those petitioners who have approached through this writ petition, Lordship. Lordship may find at page number, starts from page number 39, Lordship. The relevant page at page number 50, Lordship. May I take your kind attention, Lordship?
Yes.
In view of the aforesaid discussions, the court is considered opinion that interest of justice should be served if the benefit of EWS is granted to the petitioners by accepting their certificates. The aforesaid observation is, however, confined to the peculiar facts and circumstances of the case, as the concept itself was in very nascent stage, and there was.
When was the order passed?
Lordship.
Where was the decision taken?
Decision taken by this honorable court, Lordship.
No, against your rejection.
Rejection, Lordship. That result was declared in the year of 2022, Lordship. And I have approved also before this honorable court, Lordship. But in second writ petition, I am not a party, Lordship. That is the difficulty, Lordship. Because of my financial constraints, Lordship, I could not approve this honorable court at that time, Lordship. I am very fairly submitting it before your Lordship.
But now you are before the court.
Yes, Lordship. Now, Lordship, pursuant to that order of this honorable court, Lordship, this the authority has already passed a notification, Lordship, in the 18th August 2025. Lordship may find it at page number 51, Lordship. Annexure A. All the 6 petitioners who are in the writ petition, Lordship.
Which writ petition you are referring to?
6138 at page number 39, starts at page number 39, Lordship.
That judgment was passed in 24.
24, Lordship. And thereafter, that notification has been published in the month of August 25. Thereafter, I have approved before this, authority, Lordship. Authority did not, respond to my.
Respondents, what do you say?
Lordship, very belated claim, they were fancier, we all were sitting idle, Lordship. Now they have come, already selection process has already been covered, Lordship. Moreover, Lordship, in that earlier judgment, Lordship, this court was pleased to pass this order under certain peculiar fact and circumstance case and clarified that that order is confined to those petitioner only. So he now at this stage, after publication of that result in persons of this court order, can he be, Lordship, accommodated against that post, Lordship? He is not entitled, Lordship, and it is not a covered case, Lordship, even. His certificate is an expired certificate he has produced before the authority. As per Lordship office memorandum, the EWS certificate is to be valid in that financial year, and it is related to the previous financial year. And his certificate, Lordship, take page, Lordship, page 33. His certificate was on 30/11/2019, previous year, and the assessment year was prior to that, Lordship, 18/19. So that certificate has already expired, Lordship.
Lordship, may I submit, Lordship, responding to the Learned Council's, Lordship, submission, Lordship. The EWS certificate, there was no prescribed format given in the advertisement, though it was called that the EWS certificate must be of 2019-2020, which is clearly in my EWS certificate at page number 33, Lordship, 2019-2020. The contention is similar in every of the matters, Lordship. All other candidature, their petition was also rejected on the ground that the EWS certificate, I mean, their contention was that the EWS certificate of financial year 2019-2020 must be issued after the financial year was over, Lordship. That is in the April of 2020, Lordship, roughly. But it has been issued in the month of, I mean, in between the financial year, Lordship. That is their contention. But that has been decided by this honorable court that
I heard counsel for parties issue notice, Mr. Dr. APS for APSC.
For respondent 3, 4, and 5.
Respondents 3, 4, and 5.
For respondent number 6.
S. Porua for
Respondent number 6.
respondent 6. Who is for 1? Mr. A.P. Ghosh for 1 and 2. Since the respondents are represented, no the way the extra copies be furnished within a period of 1 week from today. List again. On 21st of January.
Can it
Should
be-
notice on the interim prayer returnable on the same date.
Maintainability may be kept open in case of delay.
It is open, we have not admitted.
Lordship, may I submit just one thing, Lordship? If your Lordship allow me, Lordship. Lordship, it is reflected in the order, in the page number 49, Lordship. There was 7 vacancies existing, Lordship. And out of them, 6 were given recommendations by the department pursuant to that order, Lordship. So 1 post is vacant just.
Not
Obliged.
today.
Obliged.
19.
May it please your Lordship, in this matter, petitioner is rejected by review medical board on the ground of burn injury, Lordship. It is annexed here.
On the ground of
A burn injury mark on the right foot with abnormal grade toenail. Page 31, Lord, 30-31.
yes, get instructions here.
Yes,
Lordship. And Lordship, I.
Heard counsel for parties. MS RDB APS, Leonard CGC APS for the respondents. Petitioner is agreed by his rejection by the review medical board. During the process of selection and recruitment and selection to the post of Constable GD in CAPF. So petitioner is agreed that the Government Medical College opinion and the opinion of the review medical board of the CRPF are in conflict and are contradictory to each other. So better let the instructions be completed by the respondent council, list again on 28th of January.
Lordship.
Extra copies be furnished
Lordship,
within a period of 1 week from today.
Lordship, item 20, 21, 22, 23.
Let us see all the matters one by one. Madhu.
20.
Lordship, here rejected.
Where is that order?
Lordship, page 30-31. Hesitation cut mark on the left hand.
Hesitation cut mark.
Hesitation cuts.
Lordship, but here,
Where is the opinion of the
Lordship, page 30-36.
huh?
Page number 32-36. Certified by the
Where is the opinion that there are no hesitation marks?
Lordship. Lordship, here it is, page 35 is clinically fit. He was rejected
Clinically
on,
fit is different. The hesitation marks are different. There has to be a finding by the civilian authority that there is no hesitation mark.
but he was,
Or these are not hesitation mark, or in spite of these hesitation mark, it cannot be conclusively arrived at an opinion that he has psychiatric issues.
Lordship, Lordship fixed it for another date.
Yes. Matter be listed again in January. On 9th January. Next.
Anyone?
Lordship rejected on the ground of hypertension, 36-37 case.
Where is it? Where is the opinion?
Lordship, it is next. Here is page 38 to 39.
What is the meaning of normotensive?
Patient.
Patient is fit from
About pressure, hypertension, no any comment or dear lords.
is normal.
What is normotensive?
Lordship, BP is normal within 120 to 180.
Oh, you're producing we're asking you from your opinion, page number 39. BP may be normal one day, may be abnormal another day. So this was done on 29/11.
Yes, Lordship.
And the civilian hospital is 112.
Yes.
You get your instructions here. We'll need the medical records.
Yes, records.
Notice learned CGC will obtain instructions in the matter. Do you want a notice here?
Yes, notice maybe.
All right, heard counsel for parties issue notice on tenable 4 weeks. Then a CGC will obtain instructions including medical records. In the CGC represents all the respondents, notices of it, extra copies be furnished within a period of 1 week from today. List this matter again on 28th of January. 28th.
22.
22 year Lordship, rejection is page 30-31. SCP for color blindness Lordship.
30.
30-31 Lordship, rejection.
Here also notice. Paper number 28.
Twenty-three.
23. Lordship, rejection is page 30-31. Due to extropia of left eye.
Due to?
Extropia of left eye.
What is the meaning?
Deviation of eyeball, Lordship.
All right. Here also notice. Returnable on the same date, 28.
24.
Yeah.
Petitioner before your Lordship is for wrong fixation of his regular pension of rupees 14,418 instead of 15,735. He has get all the benefits. Notice, Lordship.
Third counsel for parties issue notice, returnable 4 weeks, Mr. N. Upadhyay.
I am for 1, 2, 5, 6, and 7, Lords.
1, 2, 5, 6,
And
and 7. MS S. Borua for respondent 3. MSH Borua for respondent number 4. MS A. Sharma for respondent number 8. Since the respondents are represented, notices are waived, extra copies be furnished within a period of 1 week from today. List accordingly on 30 January.
Deeply obliged.
25.
Ma'am, Lordship. Lordship, matter parking the, okay, I'm sorry, sir, I'm sorry. I'm sorry, sir.
Lordship, in 25, Lordship, we was rejected by the color blindness. CP4.
Color blindness.
It is page 30-31.
All right, here also notice returnable on 28. MSRDB, learner CUC.
Obliged.
Obliged, Lordship.
26.
Herein also, your lordship, the high BP was found in the.
I,
Yes,
where is it?
this 47, your lordship.
Page?
Yes,
Sorry.
yes, 47, your lordship.
Due to hypertension,
Yes.
Hypertension.
then,
And page 48, 1 hours, your lordship.
but you mentioned about I,
I,
it's about hypertension.
no, high BP, yeah,
Oh, high BP.
yes, I know.
We only heard high.
Yes, no.
So we thought you referred I. All right, issue notice returnable on 28th. You'll need medical records here,
Yes, that's it.
including medical records, if required. List on 28.
Obliged.
27.
My lord, petitioner seeking my lord subsistence allowance. Page 6, my lord, the suspension order was suspended on 5/8/2020.
Subsistence allowance not granted,
Not,
Well,
open instruction notes.
yet instruction.
Lots.
Heard counsel for parties. The claim of the petitioner is non-release of subsistence allowance. The petitioner was suspended with effect from
My lord, with even 5/8/2025.
hmm,
It was issued on 5/8/2025 with an immediate effect. My lord.
5/8/2025.
Lord.
Five eight 2025. List on on 9th January.
Obliged.
Extra copies be furnished within the course of the day.
19 lots.
Huh?
19 January notes.
Subsistence allowance.
What's it?
Why 19? 9 January.
9 January notes.
28.
Obliged, my lord.
May please your lordship.
Yes.
But I am before your lordship with a very limited prayer, my lord. Petitioner is a selected candidate, my lord. I will take your lordship to Annexure 1. He was requested to appear for a written test and interview. Accordingly, she appeared, and Annexure 3 is the, my lord, result declared. She is a selected candidate. But 6 months has elapsed, my lord. No, she is not appointed, my lord. Therefore, I am before your lordship, my lord. With a limited
This is by selection by which authority?
by the respondent number 1, my lord.
By the garden, tea garden.
Garden, my lord.
So how can we issue a writ to the tea garden otherwise?
My lord, that is there, my lord. Therefore, a notice may go, my lord. I will satisfy on that, my lord, because a private party, but my lord, discharging public duties, my lord. It is a school, my lord. On that, I will satisfy your lordship, my lord. Or your lordship may dispose of the matter, my lord, by direction to consider my case, my lord.
Even that also, because are they represented? They're not represented today.
No, not. So notice may go, my lord. On that, I will satisfy your lordship, my lord, regarding
Heard learned counsel for the petitioner is aggrieved that in spite of a selection, in spite of the selection process undertaken by the respondent number 1, and her name being reflected in the results sheet for the A&M examination held. Where is your name?
number 1, my lord, Bandana Kakuri.
Showing her name at serial number 1
He is only selected candidate, my lord.
for the post of A&M nurse in the garden
Hospital.
in the respondent number 1's T state, whom no order has been passed for appointment
Guardian Hospital, my lord.
in the garden hospital. The result sheet clearly reflects the petitioner was selected. Representation was made on 3/11/2025 to the authorities, but the same has not been represented. So, accordingly, the petitioner is agreed before the by the inaction. What claims do you have against number 2?
Number 2, my lord, I made a party because he is responsible for industrial fish and.
Have you made any representation before the authorities?
I made representation before the Guardian Authority, my lord. That is one I annexed at page 12. And several representations I made, and one I have annexed, my lord. That is last paragraph.
But you did not represent before respondent 2.
No.
Would you like to represent before respondent 2?
That I will do, my lord. That observation may be there.
All right. The counsel for the petitioner, on appointed query by the court, submits that although the respondent 1 is a private, is not a government authority or any authority under Article 12 of the Constitution, but the nature of duties entrusted and required to be performed by the guardian, at least insofar as the labor welfare is concerned, by providing adequate health care and education. There is a duty cast on the respondent 1 to discharge its public responsibilities towards the labor force engaged in the works of the state garden. So therefore, the said respondent 1 is amenable to the jurisdiction. Better. Considering the submissions made, let notice issue to the respondents. Steps within 1 week by registered force. On respondent 1, you are appearing for 2.
Yes.
And one thing I may point out, my lord, he is not a labor, my lord, the lady, my lord. He is a person from the locality, my lord. The petitioner, my lord. And he would say.
We did not say the petitioner is a laborer.
No, it was not said in the.
We did not say the petitioner is a laborer.
In any job.
We are saying that the garden has a duty to discharge towards its workforce, including the labor. MS Kolita appears for responding to, therefore notice of the waive. Extra copies be furnished within a period of 1 week from today. The question of maintainability is left open to be decided at the time of admission, the writ petition. List after the returnable date, list on 30 January.
29.
May I, Lordship? The matter parking, Lordship, the temporary benefit, Lordship. So, Lordship, what can here in this case, Lordship, the petitioner is a second wife of the deceased employee, Lordship. The deceased employee was a driver of the Panchayat Department, Lordship. So, in the year 2019, Lordship, the DCRG has received by the first wife, Lordship. By virtue of the agreement, the 50% amount already disbursed to the second wife, Lordship. So, Lordship, one of the judgment, full court judgment, Lordship, full court judgment.
Petitioner is the first wife.
Second wife.
Second wife. Respondent 7 is the
Is the first wife, Lordship.
first wife. So what is the agreement?
Agreement, so Lordship, whatever the amount received, the DCRG wise, so 20 lakhs rupees, 24 lakhs received, Lordship, the 50% amount
Who has received?
received by the first wife, Lordship.
Respondent 7.
7, Lordship.
That has not been disbursed to you.
Disbursed 50%, Lordship, which are mutual consent, Lordship.
50% you have received.
Yes, Lordship, I have received.
How much do you want now?
So, Lordship, I have no idea the remaining part, Lordship. So, the department disbursed the 24 lakhs, Lordship, as on that, Lordship. So, my prayer is, Lordship.
Lordship, it's a private dispute between these two wives.
No, private dispute, all right. What is the amount she is entitled to? What is the amount of pension that you have discharged to the private respondent?
That I do not know, but
That you have to find out and let us know. Have you made a claim before the department?
Yes, Lordship, I submit the representation, Lordship. The several representation and the Lordship, they are governed by the Mohammedan law, Lordship. So here clear defined, Lordship, the second wife is entitled, Lordship. And the division bench says, Lordship, is as per the governed by the Mohammedan law, Lordship. Page number 32, I have stated, Lordship. Okay.
Yes. 32.
Yes, Lordship. Is a Junafa Bibi, Lordship.
Zunufa Bibi.
The parties are governed by the Mohammedan law, Lordship. So where case the parties transfer interest transfer. The second, including the second of the further wives, in case of the where parties are governed by the Mohammedan law, Lordship. Junafa Bibi, Lordship.
Lordship, it's stated there that to whom the pension would be paid, the remedy thereof would be to make a claim for maintenance in the appropriate forum.
But governed by the Mohammedan law, Lordship, so they are.
And not a claim for payment of family
family
pension by the
pension.
state authorities.
So the agreement wise, Lordship, the clear, Lordship, the whatever the amount or the pensionary benefit or family pension, Lordship, the 50% not to be provided, Lordship. So on that way, Lordship, I submit the representation one by one, Lordship. You were the concerned authority. Even though, Lordship, in the nomination paper, Lordship, my name was there, Lordship, as a second wife, Lordship. And
But there is already a direction here. On 2824, there is already a direction.
yes, Lordship.
Then what happened?
Subsequently, Lordship, they did not provide, Lordship.
They did not provide. You should have taken recourse to the remedies available to you.
So that's why, so I submit the representation, Lordship, they are subsequently, Lordship. So one by one, first representation, Lordship, on 28/11/2025. Second is 27/11, and third is 3/12/2025, Lordship. The three representation has submitted.
All right, heard counsel for parties issue notice returnable 4 weeks. Mr. A.K. Ghosh, learned counsel representing the respondent represents respondent 1, 2, 3, and 5. MS Borua 4, 6. And who's for accountant general? Anyone? MS A. Sharma for respondent 4. So therefore, notices are waived. Extra copies be furnished within a period of 1 week from today. Steps on respondent 7 by registered post ID within 1 week from today. List this matter again after the returnable date on 4th of February.
Yes. Much obliged.
Obliged.
Is it need for order, second, 12?
Some of these matters pertains to
junior engineers appointed under 3F. Your lordship was pleased to issue notice on 31/10/2025 in the IA. Your lordship will find at 18, and what the state represented to your lordship, if your lordship just have a look at page 22.
Yes.
And then it's friend, my lords, in the middle, my lords. Mr. P. Nayak, learned additional advocate general, referring to Annexure 7, submits that the last day extension of the writ to the writ petitions were granted on 13/9/2025, and which will operate till the next 4 months, that is till 12th of January 2026. As on date, the petitioners are serving, and therefore there can be no apprehension during the currency of the present extension. He therefore submits that no interim order is called for at this stage. And your lordship therefore issued notice as well as on the stay prayer. But what happens subsequently, my lords? On 20/11/25, your lordship will find that at page 26.
Yes.
They have issued a notification.
You were appointed under 3F.
3F.
You're working.
From 4/6/2019, I was working when your lordship issued notice.
You're
But
working
now,
as PWS, what?
a junior engineer, my lord.
Junior engineer. Now, there was a subsequent recruitment process.
There is the second round, my lords, first advertisement. This is the second round. So originally we had
The
challenged.
law is very clear that once the regular persons are appointed, they will have to be, unless the 3Fs are released. Your only protection
No,
is that you shall
Protection
not
is, my
be
lord, that only
replaced
now
by-
11 out of 11, one finds, as per the affidavit of the state, he is a selected. So only 10 persons are involved in this case, my lord. They have been working from 4th of June 2019, about 5 years. They were through a process, undoubtedly they are under 3F. When the second we filed the challenge, the first advertisement sought regularization, that was turned down by the your lordship. But subsequent thereto, they again reappointed me pursuant to a cabinet decision. There was a gap of 2 months. So in spite of the first advertisement taking place, recruitment having taken place, they chose to recruit me again under 3F, and that continued, my lords.
No, but what is your right?
Well,
otherwise?
right, my lords, one today IA, can they, my lords, there, it's totally, they said the interim order is not called for. Otherwise, your lordship would have granted status quo, would have granted status quo. But they projected to your lordship that my term is till January, and there is no occasion for your lordship. So if your lordship sees page 22, see the submissions made before your lordship at 22. My lord has 22.
Yes.
Mr. Nair, learned additional advocate general, referring to Annexure 7, submits that the last extension to the writ petitioners were granted on 13/9/25 and which will operate till next 4 months, that is till 12th of January 26. As on date, the petitioners are serving, and therefore there can be no apprehension during the currency of the present extension. He therefore submits no order is called for at this stage. Now, if they make a submission before your lordship that I am protected till January, the next thing they do at 26, on 20th 11/25, they say now the recommendation has come from APSC, not that those people have been appointed. Therefore, your services cease to exist.
What about the persons who are selected, they're appointed?
That's what I'm saying. 650 people are there. The first round also we saw, my lords, that after completion of the recruitment process, 100 odd vacancies still remain. Therefore, the government through a cabinet process re-recruited me. I was terminated on 25th of June 24. 2 months thereafter, on 27th August 24, I was again reappointed under as a fresh appointee. Therefore, my whatever increment I had earned from 19 to 24, but that's so be that be. Now, my lord, 650 are there. One, if they wanted to relieve me, the least they could have come and sought your lordship's leave. If they have projected that my services are protected till January, and now be that it
Now, what
means
is the status now?
But so far as these 650 posts are concerned, Lordship, government has already issued recommendation and they have been.
Why did you make a statement which
I'm coming to that point, Lordship. If Lordship comes to that notification at page 138.
We'll come back to you, Mr. Goswami.
Fine.
138, Lordship.
138.
Lordship, what if, and in fact, this petition was, I received this petition only in the morning of the last date, Lordship, that is 31/5/10/2025. And during the hearing, Lordship, I read this notification at page 138.
138
of the writ petition. But unfortunately, I read only the first paragraph.
Whatever you are.
I am coming.
But this
I'm
order
coming.
was part
I am
of
coming.
3110. You
Yes.
could have pointed out.
Yes,
that,
Lord.
These
Lord, subsequently also I mentioned this matter got listed, but on that day, bench did not say. Lord, only for the purpose of pointing out this point only, mention the matter and get the matter listed. 138, first paragraph, Lordship. It was for 4 months, but in the table, Lordship, may kindly see the last column. Extension required with effect from. With effect from 28/4/2025. That is extension for 4 months, but it was only with effect from 28/4/2025. And on the date when this matter got listed, Lordship, their extension were already over. Now, Lordship, I made a mistake. This was before your Lordship, most probably your Lordship also. My friend was also there, but it was known to the petitioner that it is with effect from April only. Lordship, if Lordship comes to page 12 of the writ petition.
No, first let us come to page 138. What are you pointing out?
That is the extension. Lordship, if Lordship reads the first paragraph, I am directed to convey the sanction of the Governor of Assam to the extension of the term of the following 101 numbers of junior engineers JE Civil of the Public Works Department appointed under Regulation 3 of so and so for a further period of 4 months with effect from the next date of expiry of their last term as mentioned below against its incumbent, Lordship. But on the basis of this paragraph, Lordship, I stated that their services has been extended for another 4 months. But if Lordship comes to the table and Lordship reads the last column, Lordship, extension required with effect from 28/4/2025, extension granted for 4 months with effect from 28/4/2025. That is, it expired in the month of August, April to August. It was a mistake on my part, Lordship. I admit that. But what is I found, Lordship, in paragraph 6 of the writ petition, it was known to the petitioner. Paragraph 6, page 12. Here he states, Lordship, that after their reappointment, the petitioners rejoined their respective posts on 28/8/2024 and have been discharging their duties diligently and without interruption since then. Thereafter, the Governor of Assam was pleased to accord sanction for the extension of their term in the department for a further period of 4 months with effect from 28/4/2025. So it was known to you, but you preferred to remain silent to get an undue benefit. Why you have suppressed that if it was known to you? I admit I made a mistake, but it was known to you.
Now coming back to 138.
Lordship.
It talks about the sanction of the extension.
Yes.
For 4 months.
Yes. But with effect from?
The dates.
Yes, last
next
column.
to the
extension
date of expiry.
Yes. For 4 months, from the with date with 28/4/2025. So 4 months to be counted from 28/4/2025. So in August, it expired. Although they continued thereafter also.
They're all same date,
Same date, Lordship.
more or less.
Yes, their appointments were on the same date. Extension were also required from the same date, Lordship. More or less, Lordship. In some cases, it is different.
Now, what is the stage of the?
Now, Lordship,
appointees?
these 650 candidates have been appointed. And out of those 650, Lordship, the petitioner number 1 got selected and he has joined service in the meantime. Now, Lordship, my first submission will be whether this petition is maintainable in the present form, Lordship, or you are praying for stay of your own appointment. In the IA, prayer has been made to stay the recommendation, Lordship. If Lordship comes to the prayer, stay the operation of the impugned notification dated 20/11/2025, whereby the engagement of the petitioners under Regulation 3 is to be ceased.
Yes.
The
Your
first
term has
question,
already expired.
this petitioner number 1 is selected, Lord. In the meantime, he has joined.
My lords, that 138 order, whatever be it, it was issued in September 13th, seeking to regularize till, according to him, in August. It expired in April. They don't do anything till September. September, they say 13th of September, that we are granting extension for 4 further months till August, but the order is issued on 13th of September.
No. Extension is with regard to the dates.
That is true, but the order is, my lords, passed on 13th September 25. And they continue till the impugned order, which is, my lords, in the IA, 20th November 2025. They also agree, my lords, I continued. Whatever may be the technicality of the language used there, the fact of the matter was that I was in service when the matter came up before your lordship. He, whatever may, I don't want to get into it, he projected, my lord, there is no occasion for any interim required at this stage because you are protected on his understanding.
Understanding that it was already
I
extended.
quite see, my lord.
Right.
But the fact of the matter, they were in service post even the expiry.
Right.
And they have been in service not from today, from June 2019.
Now
So
the regular selection is there.
there is there.
So they
And
will have to be
including-
appointed.
There is, my lord. Therefore, what I am saying, there could be another situation like it happened in the earlier advertisement. Namely, that even after the completion of the recruitment process, there was 101. Originally, 300 odd people were appointed. In 2000, they terminated in September, in August, May 25th, May 25. Thereafter, when they were reappointed through the cabinet process, in lesser number of people. Now we are only concerned with 10 people, my lord, at the moment, my lord. There could be possibility, I don't want stay of the advertisement that I can't do because the earlier round when it's the same
It's
advertisement,
up to the government to decide, really.
your lordship,
If the
normally,
government is of the view
my
that
lord.
these 10 people can
There
be
are two
accommodated.
things involved, my lords. Now, if we go on the merits, my lord, I don't want stay of the recruitment process. That I can't ask for, the large number of people. In view of the on merits, my lord, do I have a case or not, my lords? If I was in service and if your lordship had protected my services, in view of the recent line of judgments, I could have argued that I may have a case for regularization or less than that, whether it is possible to hold a limited examination qua them for that in Supreme Court in one order. But those things are on the ultimately whether I succeed or not, this my lords 3F.
Now in the regular selection, you did not participate.
Only 5 of them participate, 5 or 6 of them participate, selected in the written as your lordship records, only 1 qualified. I quite see, my lord, what falls from your lordship. But this is the hard reality and a possibility based on a precedent of the present selection process that even after completion, they may still choose, like they did on the earlier occasion. What they do is that if there is a break, at the earlier occasion, 2 months break, whatever increment that I had earned,
that was denied by issuing a fresh 3F notification. So whatever I had earned,
So
I go
really,
back.
it is up to the government now to decide if they require your services. There are
There is no
available.
doubt about that, my lords. But the whole situation has arisen because there's quite a possibility because of the length of service. If it was I was not there for lesser
Length of service.
Normally at 10 years, I have not met the.
They're all 3F appointees.
No, that your lordship is
That-
right, but in these recent judgment, labeling will not determine the.
These recent judgments are rendered in the facts of their own.
This
own
fact,
facts.
whether I'm able to satisfy
then
the
it
test
will-
of these recent judgment will be a matter for.
Then you know this is it that's a 309 rule, Mr. Mondo.
Yes,
Limitation of function rules will be rendered odious. That if anyone who's appointed under 3F will ultimately get a right.
Yes, but the courts have granted relief. Forget about me, my lord. I have come through a selection process. People who have come on contract basis, work charge, because of the length of service, and they have chosen to utilize. But whether I meet that test is an issue that has to be decided at a hearing point.
So today,
The
what is
idea
there
is-
for us to do for you?
I was a notice, well, my lords, it is for them, my lord. Normally, when a statement is made before your lordship, even if
Want a
it
notice.
notice, if they are normally your lordship they may, if a notice goes, they may recall the order. They are considering only, or your lordship would permit only 10 people are involved now. After the process, also there could be some vacancies available. That is what I have
That
ever
is
at
a-
page 15.
That is a plea you have to raise it before the government.
That representation of 19.
That is a plea you have to raise before the government. If the government feels that it is possible, then
They would, having regard to the history of the case, my lord, where the cabinet had to take a decision, there is high possibility. What they want my services, but not the, and only 10 people are involved at the moment. From earlier original, only 10 people that can go
that we
both
can't-
ways.
we
That can
can't
go.
issue a direction to the
No, I
government.
can't, unless I satisfy your lordship that I meet these tests of
We
these.
can only say that you are given liberty to file your representations before the government. Let the government consider it within a fixed time frame.
That may, at the moment, that is. the
Or
best.
we issue a notice in the IA and we proceed on the returnable date.
That would, my lords, let them, I think at the moment, my lords,
Which one?
the second option.
Second one. You want us to issue notice? Okay. Third Council for Parties, IA, the IA. Issue notice, return within 4 weeks. Mr. T.J. Mohanto, learned senior counsel, assisted by MSP Sharma, represents the APSC.
There's one more thing.
6, Mr. P. Nayak, additional AG, appears on behalf of all the state respondents, all the opposite parties, 1 to 5. Except 6, all notices are waived, extra copies we furnished within a period of 1 week from today. Pendency of the writ petition as well as the IA will not be a bar for the petitioners who ventilate their grievances by filing appropriate representations before whom? PWD.
Before the commissioner law.
Before the opposite party number 1, commissioner.
Lordship, if lordship allow me, if I mean, that is the submission of the petitioner lordship, then I may be disposed of in that line only lordship.
That is
What is
without
the-
prejudice submission.
No, on one hand, lordship is issuing notice at the.
So we are saying without prejudice, they may file. If you think the representations can be considered.
If it is agreed, lordship, by issuing that direction, lordship can dispose of the IA also. Let the authority decide. If there are vacancies even after appointing 650,
If you are
let them take a
agreeable, we can
decision,
close
lordship.
it.
But only the IA or your lordship can dispose of the IA on that, my lord's basis. The main matter may be, my lord's careful, there is something. Because there are other prayers also.
So far as the main case is concerned, lordship, one more case is there in the earlier round.
No, right now we are on the IA.
Yes.
You are agreeable to disposal of the IA.
IA.
All right, then you say don't issue notice. You say that earlier on 31/10/2025. When the matter, when the writ petition being WPC 6140 of 25 was listed before the court. On the submissions made before the court by the respondents that the last extension of the writ petitioners were granted on 13/9/2025 and which will operate till the next 4 months, that is 12/1/2026. There is no apprehension. There can be no apprehension expressed that during the currency of the there can be no apprehension expressed regarding the status of the writ petitioners towards their service during the currency of the said extension, and therefore no interim order ought to be granted. Stop. Taking into consideration the submissions made, notices were issued in the writ petition without any interim orders. Stop. Where the petitioners are serving as junior engineer civil in PWD on 3F. Since when?
My lords,
2019.
4 June 2019,
Since the year.
but there is a gap of 2
2019,
months.
And their appointments were renewed by issuing fresh appointment
From
orders.
time to time.
From time to time.
No, there is a gap in
Hey,
between.
but was terminated.
Fresh appointment orders. We are not saying extension, fresh appointment orders. So the petitioners therefore have filed the writ petition seeking appropriate orders from the court for towards regularization. You're praying for regularization in the writ petition.
My lords, in one sense, a limited examination. Regularization is difficult for because
Praying
the-
for their permanent inclusion into their services. Stop. In view of the regular selection procedure adopted by the state through the APSC, petitioners apprehended that once the selected persons are appointed, a process for appointment of selected persons are underway, the petitioners will be terminated from their services. Under such circumstances, the IE was filed. Today, when the matter is called up, the learned additional AGs pointed out that the submission earlier made is not supported by the facts which are evident from the writ petition. The petitioner's extension was granted with effect from May. April.
From 27th, that is the.
April
28 April with effect from.
With effect from April and May 2025 for a period of 4 months. Therefore, their second extensions expired well before the matter was taken up by the court on 31st of October 2025. Stop.
But they were continuing.
However, therefore, the government was constrained to issue the notification dated 20/11/2025, whereby the services of the writ petitioners were stated to, whereby it was stated that the services of the writ petitioners shall cease to exist with effect from 17/11/2025. Stop. It is under these circumstances, the IA has been filed praying for interim orders. Better. The counsel for the petitioner has urged for interim orders that The petitioners are still in service.
My lord,
And
that won't be. My lord, that ceased to.
you're not in service.
Was when your lordship issued notice, I was.
Submits that when the court had earlier issued notice on 31/10, the 2025, the petitioners were in service. And their services are necessary as according to the counsel for the petitioner, in spite of the regular appointments being undertaken, as per instructions, sufficient vacancies will be available for accommodating the services of the writ petitioner / applicant. Better. Taking into consideration the submissions made, the fact remains that the petitioners were appointed as 3F appointees under the APSC Limitation of Function Rules 1951. 51. Rules
51, regulation 51.
Regulation 51. Stop. As per the rules itself, the period of service or appointment is for initial period of, is it 3 months or 4 months?
4 months.
4 months.
That doesn't require.
Subject to such extensions being granted by the appropriate government. Stop. The petitioners having been appointed under 3F continue their services on such extensions or end of leave or fresh appointments granted by the government. Stop. However, upon regular selection, upon a decision taken by the appropriate government for regular selection, the necessity of continuation of the services by the writ petitioners under 3F are also required to be taken by the government. Stop. The once regular candidates are selected and appointed, the question of the 3F candidates, the question of extensions or reappointments of the 3F candidates will have to be taken by the government, depending on the requirement of their services. Stop. In view of the submissions made by the council for the petition that there are, notwithstanding the regular process of selection being undertaken, there are several vacant posts still available, and the services of the petitioners, which considering their experiences, would be necessary for the government, on the request made by the council for the petitioner, the court grants liberty to the petitioner to file a detailed representation before the Commissioner and Special Secretary, PWD, to look into their grievances for retention into their services, subject to availability of vacancies and the requirement of the government. Stop. If any such decision is taken by the government, the government will decide, will pass appropriate orders on such representation if the same are filed within a period of
7 days. 7 days.
You'll file it within 7 days.
Whatever your lordship.
10 days. Within 10 days.
10 days.
10 days. And pass appropriate speaking order thereon, deciding on their claims. Any such speaking order that is passed will be served on the writ petitioners. Stop. Such speaking order should be expeditiously passed within the outer limit of 30 days.
Lordship I mean, within 15 days, authority will decide. And
Right, 15 days from the date of receipt of the representation permitted to be filed by the writ petitioners. With the above observation, the IA at this stage stands closed.
Look, only one factual correction. There was earlier a termination order of 25th June 24, and they were reappointed or fresh appointment on 27/8/24. I just wanted to make that clarification. For 2 periods, they were out of service earlier.
The line after their initial appointment under 3F.
In June 2019.
Intermittently, for 2 periods, they were terminated.
One period.
One period.
From 25th of June 24, and then through a cabinet decision again appointed. On
25th of
June 24, they were terminated.
2024, they were terminated.
And then reappointed.
Subsequently, pursuant to a cabinet decision taken by the state, they were
27
again reappointed on
27/8/24.
27/8/2024.
Record of it.
Yes.
On record should be clear, my lord. Deeply obliged.
Again, 13.
Wait, Your Lordship. Lordship, the present interlocutory application has been filed for substituting the name of the petitioner to the applicant, Lordship. Lordship, the petitioner in the writ petition was the deceased husband of the applicant, Lordship. And the matter pertains to regularization of the deceased husband in the writ petition, Lordship. Yes.
When did he expire?
Lordship, on 18th of March 2025.
Any objection?
No, Your
This I has been filed by the applicant, who is the widow of late Debokanto Horma, who was the writ petitioner in WPC 1163 of 2023. Stop. The writ petition was filed seeking a direction for regularization of the services of the late husband of the applicant, who was working as a work charge power pump operator since 28/7/1994 in Megasam, lift irrigation scheme, Tumpreng, West Karbi Anglong, under the office of the executive engineer, Difu Mechanical Division Irrigation, Bokolia, which was subsequently renamed as Difu Irrigation Division, Difu. Stop. The late husband of the petitioner died in harness on 18/3/2025 and during the pendency of the writ petition. Stop. It is submitted that since the writ petition was pending and a claim has been made for regularization of the writ petitioner, namely the husband of the late husband of the applicant, the present application is filed for substituting the name of the applicant in place of her late husband, late Debokanto Horma, as a writ petitioner. Stop. Prayer made, prayer made is not objected to by the respondents appearing for the Karbi Anglong Autonomous Council and Irrigation Department. Considering the submissions made and upon perusal of the pleadings available before the court, it is seen that the claim of the writ petitioner Debokanto Horma in WPC 1163 was for a direction to regularize his services in the post of power pump operator in regularization as a grade 4, I think.
Lordship,
Grade 4?
grade 3, Lordship.
Grade 3.
Grade 3. Grade 3.
Regularization of services under the department in the appropriate grade. But you have prayed for alternatively for disposal of the representation.
Lordship. The representation was to regularize him because in the Lordship, Lordship, he needs to come to page number 20 of the writ petition, Lordship, annexure 6, Lordship.
The affidavits have been exchanged. The pleadings have been exchanged in the writ petition. Stop. However, during the pendency, the petitioner expired on so and so day. Stop. Considering the issues raised, the court is of the view that the claim of regularization of the petitioner Debokanto Horma, if accepted by this court and consequential directions are issued, then the said petitioner would have been regularized in a pensionable service. And upon the demise of the petitioner, the present applicant being the widow of late Debokanto Horma would have been entitled to family pension. Stop. Under such circumstances, this court is of the view that the right to sue survives, and the claims made by the writ petitioner can also be pursued by the widow of the late writ petitioner, namely the present applicant in the IA. Stop. Accordingly, the IA stands allowed. The applicant is permitted to be substituted in place of late Debokanto Horma, writ petitioner, in WPC 1163 of 2023. The applicant will file necessary amended course title before the registry within 2 weeks from today. Copy of this order be brought to the notice of the Registrar Judicial. I accordingly stands disposed of. And in the writ petition, you write, in view of the order dated so and so, passed in IA so and so, the applicant, namely Mamoni Horma, is substituted as a writ petitioner in place of her husband, late Debokanto Horma, who was the petitioner in WPC 1163 of 2025. The registry will make necessary changes, and the petitioner will also file amended course title in terms of this order. Matter be listed again.
Lordship. The month of January, Lordship.
28th of January.
Lordship.
Unlisted item WPC 7458 of 2025.
Maybe your lordship. In this case, the advertisement reflected that the upper age limit of a candidate should be 38 years. And there is a office memorandum that is at an extra page 25, lordship. This office memorandum indicated that for a postgraduate candidate acquiring postgraduate degree in medical science.
Page number
25.
25.
Third para. It is therefore in the interest of fair dealing to the candidates acquiring postgraduate degree in medical science and in the interest of public service concerning patient care academic quality incentive to postgraduate doctors to join government service in medical colleges, the upper age limit for entering into government service in the entry level post of senior resident tutor, demonstrator, registrar, resident surgeon, resident physician, etc. at various medical colleges of Assam is hereby raised to 45 years, irrespective of the category of the applicant, as per provision of the OM number 20. Now, the petitioner is a MD Ayurveda. He is a master degree holder, and the post advertised is for assistant professor. There is two department, Kaya Chikitsa and Agar Tantra. The candidate belongs to Kaya Chikitsa department. So, lordship, since the
This is for what appointment?
Appointment.
When is the last date?
Last date is on 5th January.
All right.
Yes.
But this has to be submitted through online or offline?
Yes, online.
Online?
Yes.
Online, they will not accept it unless there are changes made.
Some appropriate order may be passed.
Huh?
Some appropriate order may be passed because OM is there.
What some? You tell us what order you want.
Because lordship,
will a physical application
My lord, so far as this OM is concerned, my lord, just now, my lord, when I got the copy, I've intimated the Assam Medical and Health Recruitment Board authorities, my lord. They are taking up with the, my lord, director of Ayush, because as per their requisition, it has been done. They were not aware of this OM, my lord.
So
But
therefore,
it is the difficulty.
if the OM is there,
My lord.
then obviously they'll make changes. They're likely to make
Not,
changes.
yes, if it is at all made, my lord, in that case, not only the petitioner, everybody will be.
Everybody will be
So
there.
let it be on 5th, my lord.
No, but in case it is not there, and 5th is the last date.
Then, my lord, lordship will see, my lord, he has submitted an application before the authority for condemnation and all, my lord, page 27. And today, according to the petitioner, he has served it to the government.
No, we want to say, we are thinking in this line, that is it possible for the department,
My lord.
we direct him to submit the application in a physical form. You examine the matter.
That's it.
If it is, if this OM is in force, then they are bound to enhance the date and necessary changes will be made. Then his application
Or, my
can be
lord, will it be
accepted.
possible that, my lord, on 5/1, my lord, since it will be a reopening day, it will be taken up in the motion column itself, my lord, at 10:30. If in between, my lord, if it is modified, corriendum issued, he is already gets a relief. Otherwise, our lordship will take a call.
Alright.
It will be more appropriate. I will intimate the authority. my lord.
Third, counsel for the petitioner, this writ petition is filed by the petitioner, who is a person who is qualified to apply for the post of Kaya Sikitcha.
Assistant Professor Kaya Sikitcha.
Assistant Professor Kaya Sikitcha. In terms of the advertisement issued by the Medical and Health Recruitment Board, dated 11 December 2025. Stop. The petitioner is a postgraduate
In Ayurveda.
In Ayurveda, from a recognized institute or a medical college, university. Stop. The petitioner's grievance is that, notwithstanding the OM dated 4th of July 2023, whereby the upper age limit of for entering into government services in the entry level posts of senior residents / tutors / demonstrators / registrars, resident surgeons / resident physicians at various medical colleges have been raised to 45 years. Stop. The petitioner submits that, notwithstanding this same OM, the upper age limit in the advertisement has been shown to be 38 years as on 1/1/2025. And the last date for filing the application is 5/1/2026. Stop. It is submitted that the petitioner, being a qualified person, having all the eligible, having satisfied the eligibility criteria, is permitted to should be permitted to apply for the said post in terms of the government OM. However, this seeing not having been done, the petitioner has approached this court. It is submitted that he has also filed an application before the Secretary, Medical and Health Recruitment Board on 19th day of December 2025, ventilating his grievances. However, that has also not been redressed. Well, Mr. B. Gogoi, additional maybe appearing for the respondents, submits that since no instructions are available, they would like to obtain instructions. On today being the last day, last day of the court, last court working day, the matter be fixed on the reopening day, which is on 5/1/2026, which is also the last date for submission of the application forms. If it is submitted that if the department, then if in the meantime, the department decides to accept the upper age limit as prescribed in the OM dated so and so, the petitioner would be in a position to submit his applications. Where considering the submission made, this court is of the view that since the applications are required to be made online in terms of the advertisement, is it online or offline?
Online.
Online. Therefore, unless the necessary changes are effected in the website, the application furnished by the petitioner may not be accepted. Under such circumstances, this court considers it appropriate to have the matter listed again on 5/1/2026, by which date the respondent counsel will apprise the court as to any orders that may have been taken by, passed by the department regarding the raising of the upper age limit to the age of 45 years in respect of persons having postgraduate qualification in Ayurveda, like that of the petitioner. Stop. Although notices are not issued at this stage, the extra copies of the writ petitioner be furnished on the learned standing counsel within the course of the day. And it is also made clear that the pendency of the writ petition shall not be a bar for the respondents to dispose of the representation dated 19th of December 2025. List again on 5/1/2025 as the first item.
2026.
2026 as the first item.
Item 14.
Please, your lordship. Lordship, notice has been issued upon all the respondents. And the matters pertain to the provincialization of employee of the municipal board under Assam Municipality Act.
Affidavit has been filed. Are you filing any response? Rejoinder?
No, my lord, we have not filed affidavit.
Huh?
We have not filed affidavit. We have received some.
Respondent 3 is filed. Who is the respondent 3?
I am a paying correspondent. Correspondent number 3, lordship.
Municipal board.
Municipal.
Municipal board is filed. Do you want to file a rejoinder?
Lordship, on the next date, lordship.
Heard counsel for parties, the respondent 3 pursuant to issuance of notice, respondent 3 has filed their affidavit. Counsel for petitioner is permitted to file rejoinder if so advised. Mr. T.C. Sutia appearing for the state respondents is also permitted to file the counter affidavit if so advised. List again on 21st of January.
Lordship, can it be on first week of January, lordship?
First week, all right, 9th of January.
Obliged, lordship.
Supplementary for orders item 30.
We will pass orders. We thought we'll dictate in court, but somehow there are other matters left. And today being the last day, so may not be able to complete it, but we'll pass orders. We are allowing you a writ petition in terms of the order passed by the coordinate bench.
My lord, deeply obliged. Deeply obliged.
Disposed.
Deeply obliged.
Dictation available.
Item 31.
Please, lordship.
We are withdrawing it.
Yes, lordship.
On the counsel for the petitioner on instruction submits that the writ petitioner does not wish to press the petition any further. Accordingly, the writ petition be permitted to be withdrawn. So, Mr. A.K. Doctoral and CBC appearing for the respondents do not object to the prayer made. Accordingly, writ petition stands dismissed on withdrawal. Interim orders, if any, stand vacated. Pending IAs are also dismissed.
Item 32 to 43.
But yesterday Lordship had directed me to file give a short note, my lord. I have prepared it, my lord. Otherwise, my lord, it's a very short note, a two-page note, along with the dates of the persons, all the petitioners have retired, my lord, particular date, my lord. Basically, my lord, these petitioners under the ROP 2003 are getting their salaries and all this, you know. But I mean, with the coming of the ROP in 2017, which is effective from 1/4/2016, my lord. That call has not been taken by the board. That board had to need to take a call, and that till 2025, that call has not been taken. And then, my lord, from August 2022, persons who are working there, they are being given a increment in the form of a interim increment of the 2017 ROP, and these persons have been denied. My lord. That is the issue, my lord. Board is not taking the call. That's why they are before the lordship. List of all the retirement dates are given last page, my lord. They have worked, they have all retired after coming into force of the ROP, my lord, 2017.
All right, yes.
My lord, due to some medical urgency, the engaged counsel have to leave the court, my lord, for today. So, my lord, can you fix the matters on some other day?
We thought we'll dispose it.
Only thing they need to take a call. They don't take a call because of the financial.
All right, the matters were posted for disposal before this court today. Mr. S. Bora, the counsel for the petitioner, has also submitted the gist of his arguments. However, it is informed on behalf of the learned counsel for the respondents that the Standing Council Housing Board
What's the TR go?
is
he was here in the first half, my lord.
My lord, his sister is in hospital, my lord. So, he have to leave the court for.
had to leave the court for some medical emergency, and therefore an adjournment is sought on his behalf. Considering the prayers made, raise these matters again on
Lordship
6th of January.
Lordship will keep it a part as well.
6th of January.
6th of January.
All right.
Lordship